Dear viewers, welcome to Breaking the Law. I am your host, Ategeka Estella Felicity. Breaking the Law is a show where we break down the law to bite-sized pieces to enable you understand it. We shall surely not be getting you into trouble with breaking the law, but helping you understand it. Last week, we were discussing the topic rule of law. We were caught up by time, so we shall continue with that discussion today. Our guests remain the same, but I will ask them to introduce themselves again.
Thank you very much. Daniel Ruhweza is my name. I'm a lecturer at the School of Law, Makerere University, where among other subjects I teach constitutional law and constitutional history.
And my name is Michael Wing from Kaganzi and Company Advocates. I'm a lawyer and a true believer in constitutionalism.
Nice to have you all back again.
Thank you.
So we broke off last week when we were talking about what happens when it is provisions of the Constitution that are problematic. Because we've said rule of law means that we all have to adhere to the law.
Yeah.
Yes. And it is easy to adhere to laws that are more comfortable to adhere to. So sometimes we find that the laws are a bit complicated. So Dr. Ruhweza walked us through how we deal with a situation where a provision of the Constitution is the one that is problematic. It's usually provided for in the Constitution, but some of the methods will either be a referendum or where we reevaluate whether as a people, because remember we said rule of law is collective rule of the people. So we decide whether as a people we want to change this or alter it here and there, like we did for the term limits.
Yeah.
Alternatively, the Constitution might provide that consultation is done with the people, not necessarily a referendum. So consultation is done, and then through Parliament, that provision of the Constitution is amended, as happened with the age limit clause.
Yes.
In that discussion, Dr. Ruhweza, you talked about the basic structure doctrine. Can you please throw a little light on what's the basic structure?
Okay, thank you very much, Stella. When we are talking about the basic structure doctrine, in its simplest terms, we are talking about a constitution having certain key pillars without which the constitution and what it's supposed to provide for and stand for would be compromised. So even when amendments are proposed to the constitution, there are those amendments which would totally change the whole rhythm and purpose of the constitution and constitutionalism. So for example, if you say that we are amending the provision that deals with democratic practices, you are totally overhauling the whole concept of constitutionalism and changing the things that it stands for. So in this case, therefore, some of the arguments that have been made over the previous amendments of the Constitution of Uganda have been that when you, what we call in the local speak, when you touch them, when you amend them, you are dealing with those pillars that hold this whole thing called the Constitution. So you can imagine having 4 pillars of a building and then you break down one. The Constitution cannot be seen to remain to be able to stand on its 4 feet if you have cut off one of the arms. It becomes compromised. Okay. So certain amendments in the Constitution are called, are referred to as, you can entrench them, they can be entrenched, and maybe some are not entrenched, meaning you can't even touch them. So the argument that has been made is that, for example, when you talk about removing the age limit, you are dealing with the basic structure of the Constitution, because with it comes so many other things. the idea of accountability, of holding people responsible for what they have done at some point in time becomes quite difficult. Because, for example, if you have a president who is able to stand for office until the Lord takes him home, you will never find opportunity to hold him responsible when he has left office, all right, among other things. Or if you're dealing with things such as independence of the judiciary, the longer a head of state remains in power, the more prevalent his ability or her ability to appoint certain key officers because of that ability to stay. And then it becomes very difficult for those key officers to hold the president accountable or his government accountable, because like happens in Uganda today, I think by and large now all the current judges in the nation have been appointed by the current president. And so the idea, the thinking behind the basic structure doctrine is that that can compromise their ability to function. So in the simplest terms that I find possible, that is how I would explain the basic structure doctrine. Do not touch those key aspects of the Constitution that create an overhaul, and in essence you are bringing in a totally new arrangement altogether.
Okay. You've talked about appointments of different officials of the different organs of government. Yes? And we said that the judiciary is one of the key organs of government, one of those that are supposed to uphold the rule of law. Do you think it is problematic that at the beginning of this particular regime, of this particular constitution, was it a mistake to give the president powers to appoint persons like the judicial officers?
Well, in what happens in Kenya right now with the coming into force of their new constitution in Kenya, the president does not have those powers to appoint. The president can only, as I understand it, oversee the swearing-in ceremony of, say, the Chief Justice and the other judges. But the actual power remains with a judicial service, the Judicial Service Commission, which is also constituted in such a way that is meant to address influence from the head of state. Unfortunately, or fortunately, depending on which side of the coin you stand, our constitution has indeed given a lot of power to the current, the current arrangement gives a lot of power to the head of state. So whether it is the incumbent right now or someone else who is the head of state, they would still have a lot of power to appoint almost all the constitutional offices in the land, you know. And therefore, it is true, some may argue that we need to rethink that because of the amount of power that is given to the head of state. And as some have argued, if you have a problem with the law, seek its amendment. But yes, as it is right now, the power is with the head of state. Recommendations are made to him by the Judicial Service Commission, and it's up to him to appoint who he thinks is best suited for that position. So ideally, when we talk about separation of the arms of government, as you mentioned, we should not ideally see the head of state having a specific and direct say in who is Chief Justice, because the Chief Justice is supposed to have oversight on the way the executive does its role, oversight on the way the parliament does its role. Now, if that person has been directly appointed by the head of state, at least what we say on the face of things, prima facie, you can see that it's a bit of a compromising situation. and that may not be very good for our democracy. Yeah.
True.
So at the time, I guess it was assumed that there will be change of office. There will be, you know, there would be elections that would see the head of state coming in and leaving for the other one. But now that we are beginning to see the reality that we've had one head of state for a long period of time, then you begin to see the disadvantages of having the constitution the way it is. And maybe the best way forward would be to seek an amendment because of the current status and address those loopholes that have begun to be seen by us.
True.
Yeah.
I just feel like I should add, yes, the president has a lot of power, a ridiculous amount of power. But again, I guess that is the advantage of actually being part of the group that puts the constitution in place, or having the constitution placed during his regime. But let's also look at how things could have turned out if a provision of the constitution, the term limits, hadn't been changed. Because now the term limits haven't been changed, the president can't run for another term. Now, a new president comes in, he finds a chief justice appointed by the previous regime, actually finds a lot of officials appointed by the previous regime. And because of the independence of those organs, this new president can't arbitrarily change those heads of those organs. The judiciary wouldn't be able to change the chairperson of the Electoral Commission and all that one. But then his time comes and goes. The Chief Justice may remain or may retire. The next person comes. Now that third person can appoint a new Chief Justice. You'll find that the Chief Justices, especially if they are making decisions relating to someone who didn't appoint them, they would be more free than as has been described, where it's only one person has appointed not only you, but every single judge on the panel. 30 years is a long time.
Indeed. We need to take a short break right now, so we'll pick it up from there. We'll be back after this break.